Hello and welcome to Unpacking Contract Law, the UK-based contract law podcast delivering unsolicited opinions on new and old contract law cases. The purpose of these podcasts is to provide you with an insight into our thoughts, ideas and ideologies around all things contract law. It also provides us with an outlet for all our opinions, so you listen at your own peril. Each podcast will feature a new contract law case with a discussion from 3 contract law enthusiasts. And it is thus my great pleasure to introduce you to Maggie Hemsworth, Séverine Saintier, and myself, Tim Dodsworth. Welcome to Unpacking Contract Law.
Welcome, dear listener. We are on number 23 for those of you who like counting. And this one is Hotel Services Limited and Hilton International Hotels. So most people will have heard of Hilton, if not Hotel Services Limited. And this is, in fact, a sequel to podcast number 22. So you might remember, dear listener, that number 22 was the Victorian case on remoteness of loss in contract, that is Hadley and Baxendale. And this one is, as I say, a sequel to it. And I think for intro, before we get going, I should thank, obviously, I'm not on my own. Firstly, I should thank the lovely Séverine, who's sitting here waiting to outline her great thoughts. And also the lovely Dr. Dodsworth is also here to outline his deep thinking. But I should also thank Newcastle Law School, who continuing in their madness to sponsor us. So deep thanks to them. But anyway, now we get going proper, as it were. I don't think I can improve on the introduction which Lord Justice Sedley gave to this case. There's a neat little paragraph which I think he took some time to craft. So I'm just going to read it, if that's all right with you. It's not that long, so bear with me. So this is what Lord Justice Sedley said in the introduction to this particular case. He said, in the minibar to be found in many hotel bedrooms, unimagined problems lurk. The honesty minibar, which depends on guests accounting for what they have used, generates forms of dishonesty, ranging from leaving without paying to refilling bottles with water or other suitably coloured fluids. One answer to this problem was the robo-bar, a device developed and marketed by the appellants, that is Hotel Services Limited, which electronically registered on the guest's account any incursion into its contents. The respondents, Hilton International Hotels, a large hotel chain, between 1986 and 1997, used the appellant's robo-bars in a number of their hotels. Robo-bars themselves proved problematical. Their chillers leaked ammonia, which both corroded the equipment and created a risk, albeit a very small one, of injury or even fatality to guests. Repeated endeavours to correct the malfunction failed. So that's the background, dear listener. What's the argument about? The argument is about really the recovery of the losses which Hilton International said they had suffered because of this obvious breach of contract, effectively, a pretty obvious, clear breach of condition of a rather fundamental nature. And Hilton claimed damages from Hotel Services due to the failure of that company in respect of 2 of the Hilton's hotels. So, dear listener, you're very wealthy, I'm sure. You will know and perhaps have stayed in Park Lane and the Langham. But anyway, those 2 hotels were using the robo-bars for a period of time, and it was that was the heart, if you like, of the losses being claimed. Liability had been found at first instance, and the issue on appeal was the recoverability of the damages. Now, the damages being claimed was the rental allegedly overpaid by reason of the failure of the robo-bars, basically failed consideration, plus the cost of removal of the damn things and loss of profit. And the appeal was in relation to those last 2, that is the cost of removal and the loss of profit on the use of the robo-bars, and that came in at about £300,000. And the issue turned on the exemption clause, that is the meaning and applicability of it. So there's a key bit of wording, I suppose, and that's really the heart of this case. Whether or not the damages being claimed, that is the cost of removal and the loss of profits, are caught, as it were, by the exclusion clause. And really, so that means what the hell does the thing mean on its wording, and does it apply here? And the key wording is the company, that is hotel services, will not in any circumstances be liable for any indirect or consequential loss, damage, or liability arising from any defect in or failure of the system, that is the robo-bars, or any breach by the company. And then it went on. But that was the sort of key bit, I think, so that we got the essence of this. And the Court of Appeal held that the losses claimed, that is the cost of having to remove the equipment and the loss of profits on the use of that equipment, were clearly direct or natural consequences of the dangerous lack of service of the equipment. And the exemption clause, using the language consequential, tacked with the word indirect, they were synonyms for one another, and that simply not touching the losses that had arisen here. In other words, the exemption clause might have applied to other sorts of losses, but did not apply to the losses in issue in this case, because the losses in issue in this case were direct as opposed to indirect. But along the way, there was some argument as to really whether that phraseology has acquired, I suppose what I would say is a sort of set understanding as to meaning, and whether the use of phrases consequential and or indirect, or tacking them together, consequential and indirect, is that a reference to these limbs in Hadley and Baxendale that we were thinking about in podcast 22, or does it mean something entirely different, as it were? And there is a sort of line of case law which is kind of like been underlined by one or two Court of Appeal decisions, to the effect that when you use the phrase consequential and indirect, you're effectively talking about limb 2 of Hadley and Baxendale, these sorts of losses that are special or peculiar, if you like, to the parties, and the facts about which have been communicated between the parties at the time of the contract. So I suppose in this case, when we actually look at what the Court of Appeal said about that, I don't know what Séverine and Tim will say about this, but when I looked at it, I thought they basically sidestepped that problem altogether and said, well, that's as maybe, as it were, but we're looking at the wording in this particular instance, and all of that argument and difficulty we're not really getting engaged with. These losses were obviously and naturally direct, and I say obviously, they were the direct result of the failure of the robo-bars. And so perhaps more simply, they decided that simply we don't need to get into that argument. But we have that argument because we have a number of cases that are talking about it. So I guess we're using this case now as a sort of platform, in part at least, to sort of thrash that out a bit. So I think I've spoken enough. I don't know what the lovely Séverine and the lovely Tim thinks about all of that, but go on, the floor is now yours, somebody.
I'm going to leave you to it, Maggie, because I think you are saying it beautifully.
And I was going to say, we're going to lose Maggie, aren't we, to some audiobook company after that introduction?
Yes, after that introduction.
I just felt like I could listen to this for hours without any need for anything. We're going to lose you, Maggie, to some kind of...
What you're saying is my voice droning on will put people to sleep. I have only got to talk for an hour.
I am completely awake, fascinated. The funny thing in that, every time we have a podcast, I think, yeah, I am. Oh, yeah, of course. Losses, I've lectured it for years. And then suddenly you read that case and you think, oh, even, do I need to remind myself? So I think it's really interesting that what seems to be such a clear-cut Hadley and Baxendale, which we did not such a long time ago. And here I find myself last night, indeed, preparing for this, thinking, ooh, it's a little bit more complicated than, So thank you, Maggie, for that. I'll now pass the buck to Tim so that I can put my thinking cap in order to be able to say anything cogent.
I suppose the question I would ask you is, do you think it's a bit peculiar? At number 22, we were talking about Hadley and Baxendale, and that was all about the sort of foreseeability of loss. It was what was in the minds either actually or imputed. So sort of imputed, I guess, would be aligned with limb 1. In other words, what happens in every circumstances, and therefore you don't need to articulate it. And the limb 2, the sort of consequences that might happen that you perhaps would need to be alerted to before you might be voluntarily accepting responsibility for if you were the potential contract breaker. And that's all very well, because all of that is just about foresight, in a sense, and sort of factual things, isn't it, really? What you knew and what you should have known and what you discussed, sort of thing. But suddenly, when we come to look at exclusion clauses, we find that sort of body of law, as it were, being used for an entirely different purpose. And here we've got really, certainly to an insurance lawyer, well, I suppose I'd label myself that, we've got language which is not really about foreseeability at all. We've got language which is about something entirely different. And I would call this causational language. Cause, direct or indirect consequences. That speaks to me as a cause and effect. And that's not the same thing about foresight of facts. So we've got case law in one sort of section of contract law, as it were, being ripped out of that area and applied across somewhere else. So it is rather peculiar. I don't know what you think about that.
So for me, I think what took me by surprise, so this is a 2000 decision, a Court of Appeal decision, and that, I also looked in the preparation as to what practitioners had to say about it. And a quick one was for those practitioners who are asked to
draft an exclusion clause. Well, don't use indirect and consequential losses.
Yeah, trying to.
I think what took me by surprise is first of all, the division indeed of the vocabulary of what the courts have said, and indeed the vocabulary that is used in the clause itself. I've just come out of a contract law lecture where I have told my students to think of contract law as a tool. The rules here are used as a tool. How good a tool is it? Does it help the party? So I think for me, suddenly to realize that those questions are being asked actually took me somewhat by surprise. But yes, I would agree that whether what you have highlighted, Maggie, is actually, was it done on purpose? Because also the vocabulary itself to marry indirect and consequential loss. The word consequential to me does not appear to be indirect. A consequence of is therefore a direct link. So,
well, all losses are consequential, aren't they, in a sense?
I know, but the wording is really important to marry indirect and consequential. Just made me think that, and actually forced me to read the case again to make sure that indeed if we look at the taxonomy that is being done in a way in this decision about classifying, the first limb, the second limb, and then suddenly this very different vocabulary, I think is a little bit difficult to follow, to see indeed. I think you've put your finger on something that is really important, is the vocabulary.
But when you ask what a practitioner's doing, I'm assuming, given that we've got a body of case law, and in fact, I think Court of Appeal at some point in the past, about 1997, effectively said, if it ain't broke, don't fix it. And if people are using that phrase, consequential, as a synonym for indirect, and often the two words are used together in the same phrase. And it's not so much habit, I suppose, but practitioners will look to use phraseology which has been tested in some way by other poor, unfortunate litigants who've bared the cost of that testing. Why go out on a limb, in a sense? No pun intended. I've just thought of that. No pun intended at all. But I mean, why go out in a risky endeavour to craft your own wording that hasn't been tested? So there's a sort of assumed safety in the known. But it does look peculiar. And personally, I think something has gone wrong in about 1978 when you sort of track back looking at the case law. And it's the sort of phraseology and words which judges use. And constantly they say to us, the words that we use should not be viewed as a statute and pored over in that degree of analytical precision. But I think something went wrong in about 1978 when it sort of slid in this idea of Limbs and Hadley and Baxendale, and we hadn't really got it before then. And then it became sort of entrenched by about 1997, I think. There's a case in 97, which I saw sort of tracking back, British Sugar, if anyone's read that, and NEI Power, where the Court of Appeal reviewed the case law on this particular point and actually said it would take some radical difference in language or a distinct radical difference to persuade another Court of Appeal not to construe the phrase in the same way. In other words, it's become entrenched, as it were, and therefore there is a risk in departing from that because practitioners and parties have been proceeding on the basis that this is now settled and comfortable and are not risky to use. But more recently, I think there has been some move away from that. You're a fan, Séverine, of Lord Leggett as he is now. But he's on record of being critical of this sort of interpretation. Not that far back, in 2015, I made a note of Scottish Power, UK PLC, if anyone's looking at all these flipping cases, and BP Exploration. And he was critical of it. And now, of course, he's in the Supreme Court. And I'm a fan, obviously, of Lord Hoffman, as I've said before. He also said back in 2002 that he would like to reserve the point, which is Lord Hoffman speak for, I think this is wrong, but nobody's asked me. And I think we've got some move away from that. 2016, we've got Lord Justice Morbick saying in Transocean Drilling and Providence Resources, he queried whether the English cases would be decided the same today. So there is a sort of shuffling of feet quietly away from the past, I think. So I don't know. What has Tim's been beautifully still and quiet.
We are for the listeners.
He's not dead. He's not dead. He's here.
So for the benefit of the listeners, we are recording, and we are recording remotely, each of us in our little cells, but we are nodding to what Maggie is saying. So we are listening, and then there is no image here.
Well, I just put on record that Dr. Tim is not dead. Rumours of his death are premature.
I'm really torn because one of the things that I thought of the way it's phrased, isn't it? Indirect or consequential. That the fact that we say indirect first and then consequential and then go into the detail, that makes sense to me that then indirect and consequential are synonymous. Why do that? Different question, and we might want to have a conversation about that, because why use the same word again, right? That just doesn't seem to make sense. So that's one of the things. Now, I wondered in the same way, would we say the same thing if it was consequential or indirect? So
I think we would.
The broad to the narrow.
No, I think we would. I don't think there's any case law that says that the order of play matters in that sense.
No, but if we had started...
I think there are cases that not on indirect and consequential, but I think there are cases where if you look at the phrase, it goes from the broad category down to a narrowing of the category, and that actually means something in the wording.
Okay, but you're making the assumption...
All animals, and then I go down to...
Yes, okay, but you're making an assumption that consequential is the broad, or indirect is the broad. Which are you saying? I'm not sure that's the sound.
That's what I don't... Exactly.
Yeah, well, I'm not sure that's the sound, because we've got Court of Appeal saying they're synonyms. In other words, one is not broader than the other. They are saying the same thing.
Quite. So maybe we can park that idea, but it's But we're still left with the why use the same word. Why just use the same word?
But practitioners do, don't they? You can have a string of word. It's maybe you could say belt and braces. You sort of trying to cover all bases. That's not unusual.
And then there is that idea of the natural meaning of the word, consequential. So who's writing the deal and who's executing the deal are probably two different parties. Now, did hotel services have in mind to probably exclude all liability that they could? Probably.
Yes.
But is that what the solicitors had in mind when they drafted this? And if it is known language, if this is language, and we have to admit here that a lot of the lawyers, of course, take these kind of clauses from a bank. Right, this has been written somewhere, is in a bank, and you slot it together.
Yeah, but as I said, it's because it's been tested in other cases, and so it has
tested to the extent that probably not in the way that they had in mind. So then we might want to ask ourselves, well, how would they exclude direct losses? Would you have to say any direct loss arising?
Well, I don't think the argument's about direct. It's the argument about, for example, loss of profit.
Yes.
If you wanted to exclude that, then ideally, and some of the cases have done that in the past, you actually refer to losses of profit.
Yeah.
That is the clearer way of doing it. And then you don't really get necessarily into this argument about whether this is indirect or direct. The textbooks, for example, McGregor on damages, which I think is now being edited by Justice Edelman, who's a distinguished lawyer from Australia. There's been a change, I think, in the approach taken in that leading practitioner work. So any UK practitioners listening probably would know McGregor on damages very well. But in the past, when it was edited by Harvey McGregor QC, as he then was, took a slightly different view about where the slicing happened at this direct-indirect point. And I think that was matched against what the Sale of Goods Act would say. So, for example, direct losses, looking at a strict Sale of Goods Act, now 1979 approach, would say direct losses are purely the difference in value of the thing that you have ended up with, as opposed to the thing you had bargained for. That is direct losses. In other words, the difference in value. So if I buy a car and I've paid...
the market rule.
Yeah.
Yeah.
Okay.
Yeah.
So that's what the Sale of Goods Act would say is a direct loss situation in buying a good.
Yes, but based on, the common law of, because of it is based on the common law.
Yes, but it's in that context of sale of goods.
Yes.
And
yes.
What's happening is that this is being extrapolated out, that's the right word, into other settings. So McGregor on damages originally said that's direct losses, simply a difference in value calculation. Anything other than that is indirect losses. And that would naturally chuck loss of profit and consequential things like expenditure and sums that you have to pay to somebody else, for example. That kicks all of that into the consequential indirect. But more recently, I think, Mr. Justice Edelman casts it slightly differently. I think he says the normal loss is the difference between the contractual price and the actual value. So that seems to be the same sort of idea. And then consequential is anything other than that. I suppose it's similar in a sense. But in this particular case, hotel services, I think we're trying to argue that loss of profit can't be in the Lim 1 category.
Yes.
Yeah.
That's been rejected clearly.
Yeah, and I think that the Court of Appeal basically said you can't have that very strict division because it will depend on the context. And there will be some situations where loss of profit actually is the normal loss. And I think they're saying that in this particular case, that is a classic instance of this. The loss of profit on these robo bars was part of the, I'm having to use the word now, direct or the normal loss for that sort of contract. So in other words, it's too simplistic to say that losses of profit will always be in consequential indirect category. There will be some instances where loss of profit is in the normal or direct category. So I suppose the writing on the wall is, if you want to exclude losses of profit, you'd better use actually those words, losses of profit.
Yes, absolutely. I think that's a really good, that is one of the lessons that come quite clearly from the case.
So is it because here, the loss, so I can't remember at which point Lord Justice Sedley said that, but I think he said it requires no specially known fact to establish the immediacy both of the consequences of putting it right where it can do no harm and when it,
Yes.
So I think ultimately for me, because here the difference in languages in the exclusion clause compared to the first and second limb of Hadley and Baxendale is difficult because we need to remind ourselves what the first and the second limb are, regardless of whether we call the normal and the abnormal. And, there is a whole discussion. I mean, you did mention McGregor, and, he disagrees that is used to say that, the vocabulary is not.
Yes, it's unfortunate, isn't it? Because these are words that themselves are unclear or ambiguous.
Yeah.
What is an abnormal loss, for heaven's sake? It's just not helpful, I think.
Well, so in a way, it's a loss that is not necessarily in the. I kind of no. I mean, it is true that the normal versus abnormal, is difficult, and that's the Utley case. I think that gave rise to this wording, and now it's slowly being abandoned. But I think it's just trying to make the distinction between the first and the second limb. So, what is within the contemplation of the parties and what is not, or what is less so because of a special fact. So I think what I take from this is that even though the decision is important because the impact of this decision is that brings back some coherence between what the case law says and what between the case law and then what the parties try to exclude. I think that's one really important thing. But what I take from the case as well is that it's still fact dependent. So what the vocabulary used also has to be in line with what it is that the party is contemplating, or do I read too much into it? Because I think it is clear that I think Justice Sedley said that we still need to be careful on this occasion. The loss of profit was within the first limb, but that doesn't mean that it's always going to be the case. Yeah.
Well, I think they're saying we prefer to decide this purely on the language,
yes,
and the context of this particular contract.
Yes.
So that is safe approach, as it were. That is sort of mainstream approach, and to kind of like not disregard, but not get too involved with this background argument as to the limbs, as it were, and the application of these limbs in this setting. So I think the Court of Appeal is saying, look, let's just look at the losses that have been sustained here and the losses that are being claimed here, and then look at the wording that is used in this exclusion and simply ask ourselves, as a relatively simple question, at least to express it in the abstract. It may be difficult in its application, but as a question in the abstract, just to simply see whether those losses fall within the wording of the exclusion or not.
Yes.
And they are saying we don't therefore need to go through all of the past case law that goes back to 1934 or thereabouts to investigate whether or not a wrong turn has been taken, because it's not necessary, if I put it that way, to this particular decision. So it's almost like sort of Lord Hoffman's language of reserving the point when it is really necessary to deal with. So they're sort of parking that. But I mean, they do look at it and say, even if we needed to apply that approach that the Court of Appeal had previously taken, for example, in 1997, to say British Sugar and NEI Power, this is the way in which these phrases have become used. And now that's kind of like the practice. And it would take a very brave court to move away from that settled practice. So they're saying now, even if we were to abide by that, which is fair enough, you can see the strengths of that, even applying that approach, the losses that Hilton are claiming here do not fall into limb 2. So as an alternative, they are embracing that problem and saying it doesn't matter here, it makes no difference, I suppose.
Yeah, which I guess is a robust way of doing it.
Well, it's quite neat.
Yes, it is. No, it is. That's
I think when they distinguish, because I mean, on the one hand, we've got this idea of indirect and consequential. I think they deal with that quite neatly. But on the one hand, we've got the definition that we've got from Hadley. We've got McGregor's slightly different one. The differentiation between normal and consequential.
Yeah.
And then we're saying, but actually that doesn't matter here.
Yeah.
We're not really looking at that. We're not looking at the remoteness test as such. We're looking at the definition of direct versus indirect.
Yeah.
So we're saying actually these are two separate things, because the Hadley test, basically losses naturally arising in the normal course of someone normally in that industry. That's what we're looking at. And then the second part is special circumstances. McGregor fudges that a bit and says, well, normal would be every claimant, and then consequential is specific to this claimant. And then the court is saying, well, actually, we don't really need to look at that, because consequential means, in McGregor's words, something different to what we're trying to look at. We're looking at the fact-specific phrasing of consequential that's being used here, which is indirect, and again has nothing to do with Hadley as such. Here we're looking at consequential or indirect, meaning arising because of changed circumstances or a market crash or something along those lines. And so we're looking here at what comes directly. And then the question is, what was the purpose of the rental?
Yes.
The purpose of the rental was to make profit. So this doesn't mean that every time we are looking at trying to recover profit will be recoverable. It's just that the whole point of the contract was, in this instance, to make a profit, and not the profit of the sale of something. The whole rental was premised on making a profit, and therefore that has to be direct.
So it would be different.
We would see in Hadley.
Yeah, so it would have been different had Hilton tried to claim loss of profits for the hotel.
Yes.
Exactly. Yeah. So we didn't get clients in because the Robo Bar wasn't working is different to we didn't make money
on the Robo Bar.
On the Robo Bar itself.
Yes, I think that's it.
It's still being used in that sense, though, isn't it? Because if you look at, I think so. If you look at what McGregor, the text is currently saying, and as you kind of like half quote there, it's losses that everyone in that position would sustain, and anything other than that.
Profits from clients from locking up.
Well, would it?
Right, you would expect profits. A hotel having a special feature to get clients from that. That's not unusual. That's not because they were Hilton. Any hotel like that would get that.
But you can see that is more naturally embraced by the idea of indirect, sort of knock-on losses.
What are you two?
What are you two
lost?
Talking about?
Yeah, I don't know whether you agree with each other and therefore are arguing over,
No, who knows? Who
That
knows?
is one of the most perfect. If we needed to make a trailer for this show,
What are you
I think we've got to
talking
take
about?
that sentence of what are you two even talking about?
Well, I think, Séverine, that past practice has proven that we only know whether we're agreeing or not at the very end. And even then, we might not know what we're talking about. Those two things are quite different, Séverine.
Absolutely separate. One is limb 1 and one is limb 2.
It is premature to ask us, Séverine, A, whether we agree, and B, do we know what we're talking about? No, I don't think 30 minutes in, I can't safely say either of those is.
But I do know who might agree or know what they're talking about. That wasn't the most elegant segue, was it? I've done better in the past.
Tim's elegant segue is about to come, dear listener. Hang on.
Hang on right in there. Newcastle Law School provides genuine research-led teaching so that you can explore contemporary legal issues taught by experts in their field. Learn more about their International Commercial Law LLM or International and Global Challenges LLM by visiting ncl.ac.uk. And thank you, Newcastle Law School, for sponsoring us here in Our Madness.
The one thing which we have forgotten to say that we are looking at this case because it was asked. We had a request, and I don't know whether the person who's made the request is happy with the way we are dealing with it. But it certainly shows that there is indeed some discussion to be had about, the distinction and the application of the first and the second limb.
Where we were arguing, now I won't use that word, where we were debating a few minutes ago, was this idea of the losses to the hotel in a very total sense, as it were. Is that losses that every claimant would sustain? And I think McGregor, or at least the current editor, would say not. Because that is particular or peculiar to the type of claimant here.
Yes.
But you can see that there is some difficulty, really, in knowing where this line is supposedly struck. It's a very simple one to take the historic McGregor and on damages line, that direct losses is purely the difference in value of the contractual item. And anything other than that are indirect. That has a sort of purity and simplicity about it, which would mean in this particular context, the rental overpaid, the total waste of money they paid for the robo-bars, I think would happily be within that basic direct loss situation, because it is the expenditure which anyone hiring robo-bars would sustain. But I think the Court of Appeal here in this case also is saying, but that also applies to the cost of removal of the damn things, because anyone hiring the robo-bars when they're leaking ammonia all over guests will have to remove them toot sweet. And it doesn't really matter where your robo-bars are and what they're doing. So it's not peculiar, if you like, or specific to a hotel environment. It's just that would be necessary in every single case. So the cost of removal also is squarely in that sort of camp of what McGregor and damages would say the direct loss. But then the other thing is the loss of profits on the robo-bars. And that's when possibly I think there might be a difference in view being taken between maybe the editors of McGregor through time, that losses of profit sound like more particular to the particular claimant in question. But that's a difficult conclusion to make. But certainly the Court of Appeal, I think, in Hotel Services and Hilton International don't have any truck with that at all. That the losses of profit on the robo-bars are squarely with the obvious natural loss.
Yes,
and
that's why
from hiring robo-bars that are obviously not fit for purpose.
Well, for those two hotels, because it is clear that, you know, there were in the 10 years that Hilton used the RoboBar in lots of different hotels, it made no profit. So that's why those two hotels, the Park Lane and the Langham, were chosen, because in those two hotels there was a profit which was made.
Profit from use of the RoboBars. Yes.
So
okay.
Even more of a narrow contextual application to a certain extent, because otherwise they would have not, you know, the fact that
but it's still, if you like, the difference in value of the thing, because you're hiring this thing, you're not buying.
I don't on that point I don't disagree with you, Maggie. I just could not see what it is that I didn't know whether you two were disagreeing or whether, you know, we're actually saying the same thing. So on that point,
I have no idea whether we were or not. I think we were not yet at that point, because I think what we were trying to tease out was we've got direct loss, we've got indirect loss, we've got consequential loss, we've got natural loss, and we've got normal loss. And
all of those phrases are unhelpful.
Yes.
Well, exactly, because they're used in different contexts for different ideas. So McGregor's using normal.
We've got to
using natural. We've got Miller Machinery talking about consequential, but in a different way to consequential. Like we've got it in the text here, and then we've got indirect, which was Atkinson, I think, in was it Séverine or something like that. So I think there's the question the case is getting at in many cases, are there any differences between these, and are there any different applications for these? And
I think we've got to the position with the case law that normal, natural, direct are being used as synonyms for one another.
Yes.
And contrast that with abnormal and indirect and consequential. Yes. Yeah. There is a kind of like clear path at the moment that courts are saying, look, we should not get bogged down with these precise words, but simplistically, those strings are synonyms for one another. And so the central question is really whether it is correct for the law to be assigning the normal, natural, direct synonyms into limb 1 of Hadley, and the abnormal or special is the other word, consequential, indirect, into the limb 2 category, when you are applying or trying to interpret rather an exclusion clause.
Yes.
Yeah.
And I suppose
I don't know what you're sidelining Miller Machinery and saying that was a different context for that, because that would there, of course, they're saying, well, that doesn't actually exclude damages so consequential loss would not exclude damages occurring naturally and directly flowing. And then we've got, so I do have a quote actually from which might summarize what we were saying from the case. Mm-hmm. I think we might. So what they're saying there's an example of consequential loss might be the injury to the profitability of the hotel itself.
Yeah.
But when the contract is one of hire of the thing itself, it's not the equipment, but the use of the equipment. And if through breach of contract it becomes unusable and dangerous, natural, here we go, natural, or immediate, we've got another one.
I know, the immediacy is
direct. We would now say direct.
Profit,
yes.
If any, which it would otherwise be yielding, and the cost of neutralizing the danger.
That's very neat.
Which therefore
you'd expect that from you look at the Court of Appeal. It's Lord Justice Sedley and Lady Hale and Mr. Justice Ratty. You know, these are quality. If I can say that, this is a strong Court of Appeal, is it? You know,
yes.
Lady Justice Hale, as she was, then became President of the Supreme Court for a period of time. You know, these are smart cookies, as it were. This is a very sensible judgment, would you not say?
Yes.
There you are, Séverine. You were looking for agreement. We've just found
a little glimmer of it.
We've just found a point of agreement.
I know, and I think it's really neat. And so, Tim, you'll have to tell us which paragraph it is at, because I think it actually suddenly makes everything slightly clearer. So yes, we can definitely see, but also because then it brings us back to some kind of vocabulary of the Hadley and Baxendale.
Yes, but also I think we're agreed on this. If you really want to exclude losses of profit, use that word. Use that word, and maybe you have to go further depending on the context.
Yes.
To be even more specific about it, because you've got the losses of profits on the robo bars here, and we've got losses of profit of hotels. And, what losses of profit are we then talking about?
And that makes sense, right? Because what you're then doing, if you're managing to exclude that, is actually destroying a lot of the foundation of the contract. Right? If you're trying to exclude direct losses, then you are taking away a lot of why you would have entered into the contract in the first place. So you can see why the court might say, right, we're going to set the bar quite high if you're going to try and exclude direct. So it makes sense for someone to say indirect losses, consequential loss. We don't want to be liable for that, because it's far more difficult to actually predict that and to act on that. So you're saying, well, really, we're going to look at the purpose for which you're buying or renting in this case. And then it makes sense that the court says, well, you know what, the bar is quite high. If you want to exclude this, then you really have to say so.
Okay,
you have to be absolutely clear about that.
Yes, but when you say the bar is quite high, we've sort of moved away from that, I would suggest, to simply imposing on the parties an obligation as to clarity. If you're clear about excluding things, then the current approach, I'm going to mangle a bit of French now, and Séverine's going to look horrified, but it's sort of moved to a laissez-faire situation. Just be very clear about it. Of course, we've got the Unfair Contract Terms Act.
I was going to say, we also have other controls on that fairness.
That is the point. That is what courts through time have said. Because we've got the Unfair Contract Terms Act, we do not need to be strained, if you like, in terms of the way in which we are interpreting the language. The language can speak for itself. And
well,
then
it can't, because consequential in the normal language.
Well, my point.
The court of appeal here accepts that.
But my point is, it speaks for itself. My point is, the parties have an obligation as to clarity, and and the application of the Unfair Contract Terms Act to possibly strike down a clause which is unreasonable is a separate exercise. So the common law now starts from very much the approach. It's for these contracting parties who are sophisticated commercial parties. They've got lawyers. If they want to exclude ABC, then go ahead and do it, as long as it's not fraud. Generally speaking, English law is relaxed about what you're excluding, as long as you're clear about it. Whether the Unfair Contract Terms Act would strike down, it is a different exercise. Does that make sense?
Yes.
That obligation of clarity still says something, right? It's you can't just you're not going to get rid of direct losses in any kind of phrase. It reminds me a little bit of the whole idea of negligence, right? Where you have to be very, very clear about excluding it. And I think the same applies here. You're saying, right, you can exclude losses, but if you're going to exclude this type of loss, right, the direct loss, the whole point of the contract, then you're going to have to be absolutely clear that that's what you're doing.
I think you're conflating two things, because the idea of clarity goes to the interpretation of the clause.
Yeah.
Yes.
We know the contra proferentem rule. So, yes, the need for clarity. Otherwise, if it's ambiguous, it's going to be interpreted against the person.
Yeah, that's sort of gone out of fashion.
Can I finish?
That's gone out of fashion.
Can I please finish?
This is why I tune in here.
So the court could not simply say the clause is not clear, therefore contra proferentem we are discussing that it is. But the lack of clarity was because they needed to be sure what it is that the parties meant about, how is direct and indirect losses looked at from the viewpoint of the Hadley and Baxendale in then order to decide whether what it is that they were claiming was caught by the exclusion clause. So two different issues. So the need for clarity. So I agree. So what comes out of it is that, yes, now we know that if you want to exclude loss of profit, you say so, but that was not so much the issue here. The issue was how the court interprets. So that's why I wanted to say that I think that needed to be said to ensure that we were not conflating the need for clarity in the context of an exclusion clause as in relation to here, what is the meaning of direct and indirect losses in order to decide what is being... The two are linked, but they are nevertheless different. Did I make myself clear? Looking at Maggie, I don't think so.
I think so. I had some difficulty when you were talking about contra proferentem because cases more recently and right up to the Supreme Court have sort of moved away from that. It's rather sort of...
Well, Neuberger was quite clear, wasn't it? If you're going to go for contra proferentem, you're basically showing that you don't have a case.
Well,
Where did he say that?
I'm not sure he expressed it like that, but I think he's saying...
I think he used the words lost cause.
What he's saying is a judge relying or using contra proferentem these days is almost like a sort of holding up your hands and saying, I just can't, I can't do this. And so he's saying, really, it's simply now a matter of interpretation and construction. And we don't have a rigid rule that is going to enable somebody to claim contra proferentem as some sort of...
Contra proferentem is part of the
well, it's not used now. You're sort of almost suggesting it's some sort of joker card. If something is unclear, then I get my card out that says contra proferentem all over it. And I think judges, certainly Lord Neuberger, has said, look, that's not really what should be happening here. Interpretation may be difficult, but it's not really going to be resolved by resort to this Latin phrase.
He says, I've got it now. He said it's very much so referring to contra proferentem,
yes,
is very much a last refuge, almost an admission of defeat.
Yes. So what he's saying
pretty strong. That's pretty strong.
Well, yeah, but I think what he's trying to say is, look, don't use that as an argument, please. If something is it's not the way in which a court. Well, I can't say it's dead, but it's not the way a modern court would naturally make a judgment on. That not on that ground. That they would want to say, all right, the interpretation is difficult in this situation. The application of this is difficult in this situation. Nevertheless, we can find a meaning. And all I'm saying is, without resort to these sort of Latin phraseology, it may simply be a reflection of the fact that it is less likely that the parties would have excluded something which is so central to the purpose of the contract.
I think we need to discuss that next time because I've got a lot of things to say. It is entering in the Consumer Rights Act and all that.
No, that's different. Okay, that's different. That's yes, that's very different because that's statute. So we were talking about the common law approach. That's case law approach.
Statute. I know, but the statute is now entering. Can you say?
Okay, Séverine, that's fine, but that's statute. Statute may decide that if a clause could be read in two different ways, it would be interpreted as a matter of requirements of the statutory provision in the way in which your average reasonable consumer would have understood it. That's fine. That is a bit of law. It's a bit of statute law. And where it's the consumer and where the Consumer Rights Act applies, bingo, a court must follow that. There's no problem about that. But what we were talking about was purely the common law. By that, I mean case law development when there isn't any statutory provision that says otherwise.
Can we please discuss that?
Let's have a discussion about this. I feel a whole new podcast coming on. We're never going to. You know, at the beginning when we were doing the first 5 podcasts or something, we said, "Are we going to have enough to talk about?"
Well,
23 podcasts in, and I don't think there's any end in sight.
Yeah.
Tim, what is the case where Lord Newberry is quoted of sort of pouring cold water on contra proferentem? Because it's that one that Séverine needs to look at and satisfy herself that he's wrong or right.
And therefore that we need to discuss.
An excellent question. I actually saw this once as an exam question, but I
Oh,
we'll need to
God.
find.
I know you found the quote without, Google is a,
Is a wonderful.
No, he did say that. He did say that.
He did. He
Okay.
definitely said that. Otherwise, I wouldn't have.
I know you wouldn't have found it.
Sure, I would not.
Was
I
it
would not have
Marks and
said it.
Spencer's Paris-Bas?
Could be.
Marks and Spence. Okay, that would be.
I don't know. I can't remember off the top of
It
my
sounds
head.
like it would work quite well in that one.
But anyway,
Yeah.
okay, we might need to explore contra proferentem, but we would need a case to hang it on.
Yeah.
But the Consumer
That's
Rights
no
Act,
problem, but I think
Séverine,
we
is
can-
an entirely different kettle of fish, as it were.
Okay, let's agree to disagree.
Oh, let's work on let's.
No, I don't argue about that at all, because it's in statute. If the statute says in ambiguity situations it will be construed in favour of the consumer,
I know, but
bingo, end of problem.
The beauty about teaching English law is that it's common law based. So the law is also created by another primary source is, the law.
Okay, but
of
we're
the
talking
judges.
about two commercial parties here. We're talking about a case that is a million miles away from any consumer law.
I know, but even contra proferentem rule, was also in application in the, in the context of the UCTA. So, contra proferentem rule is not something which is just solely in the realm of a B2C contract. Contra proferentem rule was evolved as well through.
Okay, all I'm saying is through time, modern courts have moved to distance themselves some way from that basic Latin tag, label, and probably also the approach. That's all I'm saying. That it
and
is
I'm
not.
saying it's dead.
Wow. Okay, so
that's
So
possibly
if that's not a cliffhanger for you, then I
that's
don't
possibly
know what
a bit
is.
extreme a position.
Sandra, no,
What
who is
we're
right?
on here, right? That's
Him who thinks it's dead,
we know,
Maggie
right?
that is think on its way out, and Séverine who thinks that, hold on a minute, it's not.
It's possibly dead for a consumer, Tim,
Oh,
but
No.
in a
What?
in a consumer contract.
No.
Well, we don't.
It's very
we
much
don't,
alive.
the opposite.
Yes, but
Yeah.
but not in that form anymore. It's the format of the European language. All right, the heart of it is there, I accept, but we don't go on about contra preferentum in a consumer
just
case.
because you call it something else, it says
Well,
quite clearly,
I think
it's got to be read against or in.
Contra proferentem rule, Maggie, does exist in French, in German,
Oh,
in
fine. Okay,
so just because
Well, it
it's
was
European.
Tim saying it was
Comparative as
dead.
well now.
Yeah, well, it was Tim
I know.
saying it.
I
was
am actually
Tim.
preparing my lecture on comparative contracts, so that's why I am.
It was Tim who was saying it was totally dead, and I sort of hesitated at that. I'm not even sure you could say in English law it's totally dead. It doesn't exist for consumers in the old-fashioned way, but it does have a life. But it comes to us from European law and the statutory provisions that we've got for consumers. But we were talking about hotel services and Hilton International, and
Yeah,
there's
we were
no
at one point.
way that you can get consumer approach.
No. But I
Fine.
think it's, I think it, we're probably ready to stop anyway. But I think it's, I think it, if we can, and maybe now we can clap and stop actually because
Yes,
now we,
I think it's what is it? Natural, normal, direct ending to this one.
Thank you, dear listener.
Thank you very much.
Thank you.